Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I'll be your employment lawyer for the next 30 minutes, answering all questions about all things employment law. I'm an employment lawyer, as you saw on the screen there, at Samfiru, Tumarkin, LLP, as always, Canada's leading employee side employment law firm. Just a little bit of housekeeping. If you need to get a hold of us during this broadcast or just generally, you can do so at employmentlaw.ca, help@employmentlaw.ca, and 1-855-821-5900. Okay, can you please, if you can, send in all your questions? We've got a few here. Questions tend to be backloaded in the broadcast, and I want to get to everyone's question if I can. So if you can, please send the questions in as soon as possible. So we'll just get going, and please send your questions in as you have them. Okay. This person doesn't have a name, so or at least anything I want to identify. So I just will leave them unidentified. My employer owes me 1.5 months of wages. They are now offering to pay up if I go on temporary layoff. I don't know if I should accept or not. Are they legally allowed to do this? Well, the short answer is no. The core tenet of any employment relationship is that you're trading your labor for money. Okay. And if you've given your labor and they haven't given you money, they're in breach of either an implied term of your contract, a specific term of your employment contract, or employee protection legislation, such as the Canada Labour Code or the Employment Standards Act. So one of those things is going to cover you off. Okay? And in fact, probably multiple sets of those things will cover you to make sure that you are actually entitled to those unpaid wages. And so the idea that they can say to you, we'll pay you if you accept a temporary layoff is inherently problematic. Unless it's in your contract, there's no inherent right of the employer to place you on layoff. And so you can claim constructive dismissal if your employer does place you on layoff. And so I'll just take a step back here a second. What a constructive dismissal is it's a de facto termination of your employment, but it's triggered by you in response to something your employer does, such as not paying you. And why you'd want to do that is because your entitlement to severance is only triggered from your termination. So you could construe the behavior of the employer by putting you on a temporary layoff as a constructive dismissal and then seek severance from your employer. However, if you accept the temporary layoff, you can't then claim constructive dismissal. So what your employer is saying is accept the temporary layoff and we'll pay you your wages. That's inherently problematic, and no adjudicator, be it through employment standards, the courts, is going to be very impressed with the behavior of your employer. The question for you is, a month and a half of wages isn't going to buy you a new boat. It's depending on who you are, I guess, but it's not that much money, and you may have other concerns, like maybe you want to continue working at this employer and maybe they're going through a rough patch and you're going to be on layoff for a short amount of time and come back. Or it could be that you're never coming back, because why would you? Because of the way your employer is behaving, and why not take the 1.5 months of wages, go on layoff, look for another job and move on. It's better than not getting the 1.5 months of wages right now. Now, you will get the 1.5 months of wages unless your employer is insolvent, and that's an important consideration. You can have a wonderful, wonderful claim to severance or wages or anything else, but if your employer is bankrupt or insolvent, I should say, then you have a wonderful claim to zero. Okay, so the first and most important overriding factor in any employment law situation is, does your employer have the money to pay? And if it doesn't, that's going to affect your decision making. Or if you suspect it won't 6 months out, maybe you take 50 cents in the dollar now to get paid now. Okay, so these are important considerations to evaluate. For you, do you want to take the 1.5 months and go on a temporary layoff? Well, it depends on if you want to continue to work there or not. You could also just say no, claim constructive dismissal, and which you would do that depending on what your potential severance entitlement is, right? Which depends on what your contract says, your age, length of service, and position. But certainly it could be as much as 24 months, which is a lot of money. So you should probably, after this, speak to an employment lawyer. If you want to speak to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Always good in a situation like this to speak to an employment lawyer just to find out, is there value to a specific situation, and get advice as to what your options are, so you can decide what to do, being fully informed. I will say this one other thing: if you decide not to agree to this and pursue your 1.5 months of wages through some form of adjudication, either through the employment standards tribunal, whichever it's called in your jurisdiction, or if it's the Canada Industrial Relations Board, if you're federally regulated, and other places, or I guess in the courts if it's a matter of contract, you're going to get the 1.5 months wages. It's, how long do you have to wait, barring insolvency by your employer, of course, but how long do you have to wait for it? And how much are you prepared to, legal fees? How much difficulty do you really want to go through? All that stuff. So all of these considerations have to be in play when you decide exactly what to do here. But I don't have enough information exactly from your question, but it could, if they're saying to you, we'll pay you your wages if you accept the temporary layoff, it could be that they are concerned that you have a potential constructive dismissal claim that could be potentially lucrative. So you may want to get legal advice on that. Question, again, someone I can't identify. During a workplace accommodation due to a health condition, does the employer have the right to get your medical documentation at the doctor's office, or they threaten to stop accommodating you if it doesn't cost them any financial burden? I don't exactly know what you're saying. So this is a tough question. So my general view is, if you provide your doctor's notes saying you can't work, that's the end of the evaluation. You've provided doctor's notes. Are they entitled to clinical records to determine whether or not that's true? I don't think so. I think that you can rely on the doctor's note, and if they're not going to accommodate you, then you have, at minimum, a human rights. You have a human rights claim against them. But is that something that if you go down that road, you probably won't be at that employer anymore. They'll eventually the relationship will part ways. And I don't know what it's like in other jurisdictions, but in British Columbia, the Human Rights Tribunal has complete jurisdiction for all matters pertaining to the Human Rights Code. And the Human Rights Tribunal right now is dealing with a large backlog. And so, I've heard from various conferences that to get from filing a claim to resolution and adjudication, it takes about 4 years. And so, that's not really an efficient resolution of your dispute if the only dispute you have, or the only legal avenue of redress you have, is one of human rights. So, I don't understand the second part of your question. What are they threatening to do? Maybe you can jump back in here. To stop accommodating if you don't provide. Well, if they stop accommodating you, what happens then? Like, let's just say you can't lift more than 30 pounds, and that your accommodation is that you get help for anything you have to lift more than 30 pounds, and they stop accommodating you, and then you don't lift more than 30 pounds, then they fire you, and then you have a human rights complaint, right? So it's I certainly know other counsel will say, yeah, no, they have a right to additional documentation, but you're relying on your medical doctor, and I think you're entitled to rely on your medical doctor. So I'll just say that, but just understand, if you don't cooperate with them, be prepared for the consequences, which could be you don't work there anymore fairly quickly after your lack of cooperation, and if you don't work there anymore, your avenue of redress is through human rights, most likely, depending on the rest of your contract situation. And if it is through human rights, I don't know what that's like in each jurisdiction, but certainly in British Columbia, be prepared for a substantial delay. So you got to take all these things into consideration. You probably want to get specific tailored legal advice. I don't exactly know things to do with claims to do with accommodation and medical documentation tend to be inherently complex. So you probably want to get legal advice. And again, if you want to reach us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay. Peter asks, I work in an apartment building as a superintendent along with my wife. She was diagnosed with pancreatic cancer a month ago. We just got word that the building would be letting us go because question gets cut off because PT1. Peter, can you elaborate there? Okay, so first of all, when you work for apartment buildings, as property managers, okay. I've just been informed that there are more parts to Peter's question. I'm going to see if I can find them. Oh, that was part one. Okay. So we just got word the building will be letting us go because the company did not anticipate this becoming an issue and is becoming an issue with my focus on the job at hand. We have only been there since June this year, and the company has not given an end date. What, if anything, can be done? Okay. So going back to what I was saying, number one, you have to, do you work for the apartment building or do you work for a property management company, and the property management company works for the strata? Okay. So if it's the property management company, your claim is against the property management company. If it's the building directly, if the building is who pays you, then your claim is against the building. The building cases can be complicated because it's the strata itself, the owners of the units that you're negotiating with, and it's very hard to negotiate with 100 property owners at the same time. It can be challenging and delayed, etc. But nonetheless, certainly able to do so. And there's a lot of employees in your type of, not with respect to your wife's situation, but working for apartment buildings directly. So it certainly can be done, and I certainly have experience in that area. Now, it sounds like they're firing you because your wife got sick. Okay, and first of all, my best wishes to your wife and to you as she fights this thing, and I hope that she makes a speedy and full recovery from her cancer diagnosis. But Human Rights Code applies to you, or whatever it's called in your jurisdiction, as an employee. The employer can't discriminate against you on the basis of disability, and so they certainly can't fire your wife if they certainly can't fire your wife for becoming ill. Situation with you is a little more complicated because you have not become ill. I don't know if did you say? Yeah, they're saying that your focus has been an issue because you're worried about your wife. Off the top of my head, they're arguing just cause. I don't think they'd be arguing cause there in that situation. They'll provide you with some severance, and that's what you'd be entitled to. I don't see a path to more money for you other than that. For your wife, certainly in BC, she could claim lost wages, and then which is severance through the Human Rights Tribunal, and then they run from the date of termination to the date of the hearing, but the tribunal will impute a date when you should have found a job, but to limit the amount of severance you get. But if she's unwell for a period of time, then that clock just keeps running in terms of the amount of money. However, if she's never able to work again, then there would be no severance entitlement, because the employer's obligations to her under the contract of employment would be medically frustrated, and therefore would owe her no severance. It's a very complicated situation. Peter, you've only been there for a year or just a few months? Okay, if you've only been there for a few months, that probably will limit or will be limiting your severance entitlement substantially. If you want to, I don't see, there's no way that you can force them to keep you in the job. I think that's what you mean by saying, is there anything that can be done? But certainly your wife has an excellent human rights claim if you are terminated. You say there's no end date. Well, if there's no end date, they've told you you're going to be fired, but not when. That's not actually specifically working notice. So when they give you an official end date, then it could be that all you get is that particular working notice. I will say that in any sort of adjudication, if this comes down to it, you're going to have, and your wife certainly will have, the sympathies of the adjudicator, because your employer seems to be behaving very poorly in this situation. So, Peter, nothing has really happened yet. They've said you are going to be fired, but not when. And so you can talk to an employment lawyer now, but nothing's happened yet until they give you an actual date. I don't see there's any way that a nasty letter from a lawyer to your employer will force your employer to keep you in the job. It could. You could explore that potential option. Certainly, it's something that I've seen from time to time. Your employer is entirely in the wrong here. So if you want to explore that option, you can speak to an employment lawyer, and you can speak to us if you need at help@employmentlawyer.ca, employmentlawyer.ca, and 1-855-821-5900. But Peter, it's the kind of thing where, once the termination actually occurs, or you're provided an actual end date for your employment, then the value crystallizes, and you'll understand what your legal options are then after you talk to an employment lawyer. So again, my best wishes to your wife and you, and certainly feel free to pop back on here later on when you have more information about when it's coming to an end. But certainly your wife is going to have a human rights claim. Whether or not you have an additional claim to pair alongside it will depend on the circumstances of your termination, the working notice, etc. I hope that helps, Peter. Question from Kim. I was terminated today, stating it was due to frustration of contract. I was on a back-to-work plan, working 24 hours per week, and the insurance company is paying the other 11. Insurance company has approved this for the next 6 months. My employer argued I'm incapable of doing the job. Am I owed anything? I'm almost 60 and worked here for 11 years. Yeah, okay, so I was talking about this a little bit with Peter just now. So a contract of employment, so you're exchanging labor for money, okay? Under the contract of employment, you are owed either directly, explicitly, or implicitly certain obligations from the employer, and one of them is severance upon termination. And the amount of your severance varies based on what your employment contract says, and then if there is no contract or it doesn't limit you in any way, your age, length of service, and position. Okay, but there's a doctrine in law called frustration of contract, and that's where, through no fault of either party, one of the parties or both are no longer able to perform the essential tenets of the job. So in this case, actually doing the job. So think from a macro perspective. Well, I'll back up here a second. So in order to make out frustration of contract, you have to be totally unable to do the job on a permanent basis. Okay, so think of, you work in a factory and the factory gets burned down. There's no way you can work anymore in that factory, and the factory is not going to be rebuilt. There's a famous case in Ontario where that happened, but there were plans to rebuild the factory, and so even though the factory burned down, it wasn't frustration of contract because the factory was going to be rebuilt, and so the employer could continue to employ the employee after the factory was rebuilt. So in frustration of contract, if you're not able to perform the job on a permanent basis, the obligation to provide you with severance by the employer is extinguished. Okay, so you're owed zero. Now, the most common way that this comes up is in medical situations. Somebody gets an illness and they're unable to work for effectively forever. Okay, they're unable to do their job effectively forever, and at some point, usually about a year and a half to 2 years in, at least a year and a half, but maybe longer, if the employee hasn't worked that long and there's no possibility of a return in the reasonably near future, the contract of employment is frustrated. Okay, but that's not what's happened here. You are trying to come back, okay, and you are working with the insurance company to come back on a graduated basis. Okay, so you're able to work, but what your employer is saying is you're not able, and I mean, these are very complicated fact patterns, but you've probably got some need for an accommodation, which the employer says it means that you can't perform the fundamental terms of your employment on a permanent basis. So if you have I'll give you an example. So your job requires you to lift 50 pounds on a daily basis, and you now cannot lift more than 30 pounds. And you have a medical opinion from your doctor saying you will never be able to lift more than 30 pounds without accommodation. The employer can say, well, listen, she's never going to be able to do this job because she needs to be able to lift 50 pounds. And the question there is the ability to lift 50 pounds a core component of your job? And if it is, then it is entirely possible that you have no right to severance. It's been extinguished due to medical frustration. If it isn't, or can be reasonably accommodated, then your employer has in effect terminated you and you have a right to severance. Okay? So, Kim, these are very hard cases. Nonetheless, you, more than anyone else I'm going to talk to today, needs to talk to an employment lawyer immediately. If you want to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Kim, if you're in BC, please feel free to reach out to me. I do have quite a bit of experience in that area. Maybe if the moderator can post my contact on the screen. There it is up there. If you're in BC only, I only practice in BC. But yes, Kim, you need to talk to an employment lawyer right away. Okay, Ken asks, I actually don't know what Ken's saying. So non-union, full-time, 7:30 to 3:30, public sector, okay. 69 years old, 19 employees under this group. I get the lowest wage increase in some years I get nothing. Is this a constructive dismissal? No, so if you're alleging that you're being discriminated against on the basis of your age because you're getting the lowest salary increases and sometimes none, you're going to have to bring some evidence for that. It could be that you don't do as good a job as, I'm not saying this, but it's possible that the other people do a better job, or maybe they just like you better, or like the other people better. It has to be discriminatory to be an actual problem. Second one, he works at a hospital as casual union. Can you continue working at this job if I take a medical leave from job one? Okay, that is a really interesting question. The short answer is probably not. Okay, so think about what a medical leave is. I am ill and I'm too ill to, at this moment in time, to do your job, to do this job. And so how can you do another job? Now, there is a case that says, actually, if you're too ill to do one job, depending on the nature of it. So if it's a mental stress issue, specific to the job or the people at the job, and then you moonlight doing something else, that's not actually a just cause termination, because or won't result in just cause termination, because the other thing didn't implicate the health issues that caused the leave in the first place. But do I like the optics of that for you? Not really. It depends on why you're taking the medical leave from one. The second one is a hospital job that sounds pretty stressful. It sound like it. I wouldn't try that without the benefit of legal advice. And I would say, even with legal advice, and you get the green light from whatever lawyer that you talk to, I think that opens the door to unintended consequences. Like, once you do that, if your employer at job one finds that out, I think it could go real sideways on you quickly. You might lose the job. You have no idea how it's going to go. So I think that if you're ill, and you probably can't work both jobs. But working one while being ill from the other, very narrow circumstances, and it has to be real. Not something that is kind of, I'll just say it has to be real from a medical perspective. We'll just leave it at that. So I'd be very careful with that one, and I'd get legal advice. Corey asks, how does finding an alternative job during working notice period affect a lump sum payment with final release at the end of the working notice, and would it affect a year-end bonus? Yeah, so if you've reached some sort of settlement deal with your employer upon termination that says, we're providing you with a working notice period, and if you find a new job during that period of time, we will pay you, say it's 12 months, and then we'll pay you 50% of the remainder. That's quite common. Your entitlement, whatever the percentage is, would be in the settlement documents. I think that's what you're asking. Okay, so just read the settlement documents and it will tell you. Most likely it's 50%, but I of the remainder. So after 6 months, you find a new job, and therefore you're entitled to 50% of the remaining 6 months. So you get a 3-month lump sum payment. That's generally how it works. And then how would it affect a year-end bonus? Well, again, that'll be in the settlement documents. But if you are continuing to be on working notice through the end of the year, then you'd be entitled to the bonus, or at least you should be, depending on what your contract says. However, if you get 50% of the remainder, what happens with the bonus? I have no idea. It depends on what's in the settlement documents, and I would encourage you to look at that. And if you're unsure about that, find out from the employer. Okay, we got 2 more. I think we can get it done. All right, Ken's back. First job, supervisor gives him negative comments regularly about his performance. Are they intended to force me to retire by not giving me I can't speak to their intentions. So are they trying to force you to retire by not giving you wage increases? I don't know. I can't answer that to their intentions. What you have to decide is if you want to continue to work there or not. What kind of severance claim do you have? Before you resign, you're going to want to find out if you have a good severance claim, and then if they are mistreating you and you have a good severance claim from that job, I'd probably keep a diary of how they are doing so, the dates, and who's involved in what's done or said to you, because maybe you'll be able to build a case for constructive dismissal, although that can be very, very challenging. So Ken, you may want to talk to an employment lawyer. I'll give the details at the end about that, but it sounds to me like you've already made up your mind about job one, but not giving you the raises commensurate with everybody else is nothing, right? The only time it's something is if it's on a discriminatory basis. I think there was, and I didn't, at least in BC, maybe other jurisdictions, there was discussion about, I haven't really got into it very much because there's no remedies, but as of yet, but equal pay So there might be something in there, but I think for you, be discrimination on the basis of age, but you need evidence of that rather than they just, the response would be, we just don't think Ken does as good a work as everybody else. So anyway, I'll leave it with you on that one. But generally speaking, someone else is getting a bigger raise than you. Well, employers are allowed to pay differentially, right? Rewarding better performance or team player or whatever it is. And I don't see that unless there's some evidence that they're just deliberately trying to force you out, or they're not giving you more money due to your age. And I think that would be a hard case to make. Okay. Can an employer force you, is a new question, force you to quit if you need to take an unpaid leave for medical reasons? So you're going on a medical leave and your employer is trying to force you to quit. I don't know how it would force you to quit, but the short answer is no. And if they did, you could probably treat it as a termination and then go after severance. So you may want to talk to an employment lawyer. Ken's back again. Job one causes me grief and they were bullying, but I enjoyed my job too, and the hours are different. Yeah. So again, what I said before, Ken, if they are bullying you, there are options for you. You can make a bullying and harassment complaint. You're protected from reprisal to an extent. You can note down everything they're doing to you in a journal and then try to build a case for constructive dismissal if you've been there a long time, and because I think you said 19 years, and you may have a good severance claim coming to you. It sounds like you really don't like it at job one, so I'd probably speak to an employment lawyer and see what your options are potentially. Okay, last one. Employer creates a toxic environment. What can I do? Exactly what I just said. If your employer is bullying and harassing you, there's not a lot in terms of remedies. You can make a complaint through the occupational health and safety regime in your location, and you can of bullying, harassment, threats to your safety, etc. And there'll be an investigation. Probably nothing will come out of it, and it'll certainly sour the relationship there. But if you make such a complaint and then your employer fires you, then and I can't speak for every jurisdiction, but particularly in BC, you'd have what's called a prohibited action complaint for reprisal for you making a complaint about your health and safety, and then you can certainly get severance remedies through that. Other than that, you can keep a journal of all the things your employer is that anonymous? No, it's definitely not anonymous. Nothing in employment law is anonymous. If you're making an accusation against your employer, probably you're not going to be working there very long. And it's not anonymous. The other thing you can do is keep a journal of the bad behavior on the part of your employer. What happened, when it happened, who was involved, what was said to you, etc. And you can speak to an employment lawyer. And if it turns out that there appears to be a campaign on the part of your employer to have you quit, or it clearly doesn't want to be your employer anymore, then you may be able to make an argument for constructive dismissal. Constructive dismissal is where your employer, through its actions, has effectively, in this case, repudiated the contract of employment and terminated your employment because of that, and then you can access severance. And the only reason why you'd want to do that is if you had a decent severance claim, which depends on your employment contract and then your age, length of service, and position. So, Jen, if this is a road you want to go down, you want to talk to an employment lawyer before you do anything. And which leads us to the end of the show. If you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Thanks for the questions today. Lots of good questions. I wish everyone a safe and wonderful weekend. I'll see you back here in 2 weeks. Join us on Monday with Chris Justice on Monday, October 1st, 1:30 p.m. Eastern Time. I'll be back in 2 weeks at my regular 10:30 a.m. time slot. Have a good weekend, everyone.